or you pay a fine of 500,000 naira, or both. So the law has changed because they found out that they need to protect the women. And that is why they created this law. But this is applicable to Rivers State. Abia State has its own law. I hope you understand. But generally in Nigeria, there are cases that have already settled this issue. But Rivers State made it special and made it protect the civil aspect and also protect the criminal aspect. Because in the civil case, because the matter will end up in court, is that the court will force the daughter or the wife to inherit what she was, a right in the property. And apart from jailing you, or ask you to pay a fine, or both. Let's rush. I have just a few more minutes. Costs to deal with the inheritance issue. That is another one. Somebody was discussing with me in this program that I was talking about next of kin. And I tried to explain to him that next of kin, most times when you hear that somebody benefits based on next of kin, those are informal arrangements. You don't inherit property based on next of kin. Next of kin is that when you are filling your form maybe for employment, they need somebody they can contact. That is why they put that word, next of kin. That does not mean that should be the beneficiary of your estate when you die. That is the person they are supposed to contact. But some companies that are informal, they can just contact the next of kin and just settle. But that is not legal. That is not official. And because of that, to process your inheritance is very expensive. The state charges 10% of your wealth as tax. 10%. That's what they charge. Take note, this is only when you want to claim ownership of that property. Take for instance, my dad died without a will. But because we are not trying to claim ownership, we have possessory right. We are in possession of the property. I hope you understand. So we are just continuing like that. I hope you understand. If you just to have possession, you can continue. But it is when you want to claim ownership. When we use the word ownership is you can buy, you can sell, you can destroy, you can do whatever you like with that property. For you to have that right, you need to go through a process. Even if you have a will, you still go through that expensive process. Government will ask you for 10%. If you also don't have a will, there's another process you go through, but you still pay that money. So that is another burden people carry. And that's why many persons who do not have these resources do not execute a will. They do not go ahead to take ownership of their father, brother, or whatever property. And especially if the money is in the bank. I hope you understand. How do you access that money? Because if it is 10 billion naira, you have to raise 1 billion to claim it. So you are rich, but you can't access that 10 billion naira that your father gave to you. You can't. You can't do any magic around it. So that is part of the issue. But we'll look for solution. Take note, gratuity is not taxed. If you retire and the beneficiaries are pursuing gratuity, they don't tax 10 kobo from that money. All the money goes to you. And last challenge we normally have is if the testator has mental issue, it will affect some things if it goes to court. If a testator make a will and says some things, the beneficiary has a right to challenge that will. I'm talking of a case where a person has a will and the person has mental issues. Based on that mental issue, it can be a ground to void or cancel that will. Let's start rushing to the solution. The first solution is that you need a legal advisor. That's the first one. To guide you to deal with your case specifically. You need a legal advisor. That's the first solution. The second one is make a will. Because if you have your intention expressly spelled out, how you want your property to be managed, it helps to eliminate crisis. The third one is, because of that, I mentioned issue of cost, 10% you pay as tax. We as lawyers sometimes give advice to those who care to listen. Some persons share their property while they are still alive. Whether the beneficiaries are aware of it or not. That's secondary. So we lawyers can tell you, why don't you make like that property, a property, why don't you prepare what we call a deed of gift and issue it to somebody. You must not give the person the document. Those documents are stored. So that when you are no more, that person will use that document to claim ownership of that property. The person will not pay 10%. I hope you understand. And so I'm